Mic check 1, 2. We got it going on. Mic check 1, 2. How you do? Okay. All right, we fixed it. The audio program is working. Robert Tangway here, live and full in effect. We're just going to share that to some people. What? Oh, I can see myself on here. Isn't that crazy? Look at it. It's the echo effect. Robert Tangway here. We're just going to wait for some people to get on. We can use the whiteboard. It's going to be pretty cool. We got someone live here now. We got one person. This is amazing. So I said some really good stuff on the last 4 videos that I posted. And we actually have some new people, new subscribers who have been seeing our videos. So I'm just going to give people a minute or two to come in, and then we can get started. I have some things to talk about, and this is kind of a test. We're going to figure out what we can do as far as this technology, whether I can take these videos, these live streams, which I can, I believe, and then chop them up and make them into more edited content. I want to remind you that if you do chat and say what's up, like I will right now, hi, your username will show up. So I don't know if anybody's live. If anybody's live there, please join in, say hi. We're not going to be talking about anything that's illegal or anything of that nature, but we will be at some point kind of coming together and going over some of the personal stuff that's in my case, but I'll redact everything. I am not a lawyer. If you are not subscribed, please do subscribe to this YouTube channel because we're going to grow it to be very big. I'm Robert Tangway. Like I said, I'm not a lawyer. I am a marketing and sales professional, writer. I own a bunch of websites, one of them being Easy Legal Suit, but however, this is not legal advice. I'm just a concerned parent, just like you may be, and working with legislators and trying to work with people throughout the system to no avail. So I might as well get into it. We got 2 people here, and we can see what we can do to chop this stuff up in the future. Anyways, so I wanted to make sure that the sound was working. How does the sound work? Does it sound good? I see 2 little bars, so I don't know what we can do to turn that up. I know I can get an external mic, which I do have one, so we might have to start doing that. If anybody wants to tell me how the sound sounds, that would be wonderful. So anyways, let's just give some background. I have 2 children, which I haven't seen in about a year. One is 4 and one is 7. And this all started, with the family courts. I left the paternal home in September of 2000. I'm sorry, in November of 2021. And then we didn't file, or she didn't file a parenting petition or anything until September of 2022. So almost a year later did it take for her to file anything. I thought we were going to get back together, but that didn't happen. The reason why I haven't seen my children is because there is a fictitious domestic violence petition that was filed in direct response to a motion to order mediation. And I did that, and I have it. So this is right here. This is 1/5 of all the paperwork that I've had to deal with, and I have it organized. So I don't know if you have the whole idea of this channel and Easy Legal Suit is to kind of put the power of the courts and the legal system back in the hands of the people. And that's kind of what we want to do. I want to make sure that the lighting's here. I'm going to be reading some of this stuff, some of these pleadings. You know, I can show you my first pleading. These aren't redacted, so I'm going to say, but the first pleading right here this is my first pleading that I filed, and it's handwritten, right? And then we can go when it started getting serious, and it was short too. When it started getting serious, we have these massive legal pages, and they're all by index, very professional. It's my contention that I could be a lawyer and probably a better lawyer than most. However, I'm not a lawyer, and this is not legal advice. So we might read some of these. I'm going to go and explain how the court system works, in my opinion, just freestyle, and then we can chop it up later. And again, this was just a test. We have been getting some new subscribers for the videos that I've posted of my hearings, and feel free to chime in if you want. I think this is a great tool, but like any tool, you have to practice it and use it before it works. So without any feedback from the audience, I will just get into what I think the court system is currently run, and this is my idea. And just with my dealings for a year, going to every agency, talking to lawyers, and talking and going through the court system, representing myself. Let's see. We'll do that. We'll do this. Okay. So, never done this before, but this is the court system or the legal system in New Hampshire. Up here is the Supreme Court. Here are the police. Sometimes they get involved, sometimes they don't. Here are the people, right? Now we're going to call this families, because we're dealing with the family courts. There's 4 districts of courts. There's the family courts, which is in the circuit. It's a trial. We also have lawyers here too, right? Lawyers are part of the court system. We have the trial courts, family courts. We have the superior court. And we have the appellate court, right? All run by the Supreme Court. And within that, though they claim that they're separate, which they're not, there is the JCC, Judicial Conduct Committee. There's the Bar Association. And in order to be a lawyer, you have to be a part of the bar. And what happened in my specific case? Again, this is just a trial run. So what happened in my specific case is that the mother ended the family, kicked me out, sad, okay? Kicked me out and kept me away from my children, from being, this is the fact, waking up with them, going to sleep with them in the same house, bringing them to school every day, walking to school, so on, things like that. So she decided that, and then 2 weeks after I left out, well, she posted online and ended up dating a police officer. Then the police officer, who was married at the time, having an affair, and going through a divorce while living in the same building as his ex-wife or current wife at the time, which it used to be illegal to, by the way, to have an affair or have a relationship with a person who is, while you're still married. It was a misdemeanor until 2014 in New Hampshire. But anyway, so she went to the police. And then they ended up breaking up. But before they broke up, she took my children out of state to Massachusetts. while hiding their location and against my permission. That right there is a Class B felony, not only conducted by the police officer, but by the mother. And that has been a law since 2005 where it states any person. So, in all that, then they broke up. Then she hires a lawyer while I'm working full time and going through all this mental stress. She hires a lawyer who sits in the Bar Association, by the way, and the Women's Bar. Okay, she sits there. Now, we have the lawyers, which go by the Bar Association, officers of the court, all controlled by the Supreme Court. She files a parenting petition in September 2022. Then she files, without calling the police, except for her ex-boyfriend, who she started to get back with, is believed. Not sure for certain, but there's plenty of written things. So the lawyer wrote a domestic violence petition for my ex and submitted it to the court in direct response to a motion, which is required by law, to order mediation. I wanted to work it all out. I started my own business, back up again, and then also signed up for classes in marketing for certification for Salesforce. She goes to a lawyer who then files a domestic violence petition, brings it to the trial court, where a judicial referee sat and lied in court at the trial courts. And then from that point, in the trial court, they issued a false finding of fact and sent it to the police. The lawyer wanted to separate. The more contention there is, they make more money separating families. So she separated me from mediating and working this out for what's called lucre. She did it specifically and lied in court and filed that to separate us so that she could be the only point of contact and gain strategic advantage in the family courts. So she separated us, and this was prior to the first hearing for the parenting petition. So she filed the parenting petition. A couple months later, when I said, hey, let's mediate this out, filed with the court. 2 days later, she filed without any notice, a domestic violence petition. We went to court December 13th. It was a sham. I put that recording up. However, it was removed. I will put it up on another platform. That resulted in physically and mathematically impossible findings of fact, which are not heard by the Supreme Court on a mandatory appeal. So in the family, there is no superior court. They got rid of that in 2005, where there's findings of fact and such. If this all goes over your head, that's okay. I'm trying to explain this in a way that people might understand, the everyday person might understand. So, look at these scribbles, looks good. Police, now notified that I am not allowed to talk to the mother, only through the lawyer, which the lawyer charges. False claims, all before the parenting petition, took away all my rights to be a child and said that I must, if I want to see my children, I have to go to the police station. The same police that didn't take my call in July of 2022 for basically what's called kidnapping my children. False and physically, mathematically impossible findings of fact, which were used against me in the parenting petition to further that. And then they filed then they ordered illegally a child support order. If you have any questions, feel free to ask. I don't even know if anybody's watching anymore. We got one person watching. Sounds good. Anyways, so physically and mathematically impossible findings of fact. We're using the family case. There was two different cases, the trial court, the circuit court. So I begged and pleaded with the courts through multiple filings. This isn't the domestic violence one, but multiple filings, 5 pages, 8 pages, 9 pages, 10 pages. I went and filed multiple times because I didn't want to go to the Supreme Court because it says findings of fact are final. And I knew that, and I said, hey, this is physically and mathematically impossible. Anyways, months go by. I write a 40-page brief to the appellate court. I write a 480-page compile appendix. There was no way I went line for line through the hearing where she lied and so on. And they dismissed it because they don't want to hear anything like that. So that's gone. And then we have the parenting petition. And from that point, the parenting case is all fraudulent too. It's stuck in this trial court by a judge who gets to do whatever they want. And that's the sad thing about this is that the JCC is the Judicial Conduct Committee. It all gets decided by the Supreme Court. No matter what the laws are, what laws are written, it all gets decided by the Supreme Court. They decide whether something is illegal or not, or the facts of the case matter. And the only thing above that is the U.S. Supreme Court. You'll get treated pretty fairly in any court. I've been to other courts, even as a criminal. I'm not saying that I have been. I'm saying I've been to other courts in California and New Hampshire, and they treat you reasonably well. It's not until you end up in the family court that they treat you poorly. And they do that with the Women's Bar Association and fictitious domestic violence cases. And so this is a very sloppy outline of it, but I'm hoping that someone's going to get some value out of it, or I will practice displaying it properly in the future. So we have this, and now, currently, I've gone through the family courts, and they're sitting on a final order because I brought to their attention that they've broken tons of laws. And again, this is not all of it, but tons of laws, which I'm going to read right now. I hope I brought that with me. I might not, but if not, I'm going to read something for you anyways, and then we can probably use that in another video. It's going to be a video series. So you have me in the family courts. The domestic violence has already been thrown away, meaning they confirmed that I committed domestic violence without arresting me, bringing me to trial, having a fair trial, cross-examining witnesses, and so on. And the physically, mathematically impossible false findings of fact, which the attorney knows are false, and the mother knows are false, and the police officer, ex-boyfriend, which she's no longer with, but still kidnapped, all know is false. And by the way, the strategic advantage that they gain in court with the DV, which was filed just before the temporary parenting hearing. Well, what is that? Interrogatories, no questions, you can't really ask. Yeah, you're not allowed to address well, they say you're not allowed to address the other party in court, and the poor victim, and I'm just this insane person, but it's mostly like the discovery. So I know that the police and the mother were together because she told me. I saw her. I had keys to the house. We were there. I slept over the house sometimes with the children when they were sick and so on, until she met this controlling boyfriend. And we're going to examine those things more in the future. And by the way, he broke the law, and the police are covering it up, and the judge is covering it up, and the courts are covering it up, and it's all in the family court record, so I can say all this stuff because I have the evidence and the proof. And that's why they didn't give me a fair trial, and they continued to bury it. They gave me a default hearing, which I was not legally default. So this right here is money. It's like printing money, because no matter what, if you go to court, whether it's family or not, if you go to court and say you win $1 million, all they have to do is have the right law firm, and the Supreme Court gets to decide whether that judgment is valid or not. And they can write whatever they want because there's no oversight. Typically, it's fair because we're usually just talking about money. But now, right here, we're talking about love and hearts, the meaning of life. And that's what they can't do and do to be just. And everybody knows that. But just in certain specific instances, which we're going to discover what those instances are when the legislator lets me present properly as a guest with the written report, nice and calm, then we're going to find out what those high contentious cases are and why they become contentious. It's because the lawyers benefit more money, and the lawyers become judges at the trial courts, and then eventually it all works up to the Supreme Court. We still have one person with us, but that's okay because we're recording this and getting practice. So let's start out. I actually want to show you guys this thing. There's a thing called production value in any content. So this is actually really easy for me. I'm basically just talking and I'm making content, right? Nobody's really watching it now because everybody's on the beach having a good time. Now we got two people. So everybody's on the beach having a good time, which I understand, and they should be. I would never be doing this if my life has not been ruined by the family courts and vexatious lawyers, which work for lucre and money. So this was in the packet that was given to me and given to every family when you first become involved in the family courts. See how it says mediation? The only thing that precludes mediation by law, because it must be ordered by law. It's part of what's called RSA 461A. I forget which statute, but I know that at which section of it, but I know that it's in the law that the court shall order mediation unless domestic violence, which is the strategic false claims, the strategic advantage gained by, I forgot to add that, by filing domestic violence. Because in mediation, it's all confidential unless it is found that the person, the party, and this is in law too, party violated the law. So I read all this stuff. I read all of this stuff before doing anything. And so what we're going to show you right now is we're going to read my first pleading, and I'm going to redact everything. And again, it was handwritten because I was working full-time, had insurance, had everything. And so here's a copy of the first pleading with the orders. And it doesn't have, hopefully it doesn't have anything. This was a motion made on a form. Motion for hearing the deposition of petitioner's counsel from November 21st, 2022. Petitioner, I, Robert Tangway, state the following facts and request the following relief. Petitioner's counsel has not been cooperative and has threatened criminal prosecution without substantiating claims. Also threatened if I spoke with my contacts, potential witnesses, ... Please see attached writing to hear reasons to compel. And then I had to cross out 8-page email exchange, checklist, cover sheets, ordering, setting the rules for this court. And please schedule a hearing as soon as possible with Heidi Ames, which is the attorney, to discuss, present, and rule on relief requested in the type long form motion to hear reasons to compel. So we have this and we have orders on this, which were made after the domestic violence hearing where the fraud took place. Motions to hear reasons to compel cooperation and civility from petitioner's counsel. That's what I wrote while working a full-time job. I wanted civility. Neither petitioner nor Heidi Ames has cooperated with me prior to or throughout this action. They have offered mediation in meeting only to rescind that offer. Petitioner failed to file financial affidavit NHJB 2065F with the court as ordered. Important items were left out and was not sent to me until after petitioner's counsel had a chance to view my properly filed affidavit, and it was late and still is not proper. So she requested discovery prior. It was a trick. She wanted to see what I had, but she was the moving party. Not the end of the world. Petitioner's counsel has continually berated me, making threats and orders based on and verbalizing assumptions without asking questions. This has caused me great stress, which affected my performance and mood at my full-time job and appears to have been done with malice. These include, but not limited to, 1, that I quit my job, 2, unsubstantiated threats to file for harassment, stalking, and domestic violence, 3, that I get a lawyer, counseling numerous times. Look at the light. Oh. That exchanges be initially at the police station. That I was to stop talking to specific people that were my friends, I knew or were in contact with my children, and could have information about the case saying it was a crime. So this is when I knew that she already that she already committed a crime, a felony crime, interference with custody, 633:4. That this behavior continued in subsequent emails without acknowledging that facts, thoughts, or solutions from me had merit or could be upon further examination. 9, petitioner technically had an affair, was the mistress of a married man. 10, petitioner had an anger problem that she directed at me in front of the children. 11, petitioner had a video of her masturbating on her 6-year-old son's iPad, causing inappropriate ads to be shown to him, and was continuing to subject Tangway children with that risk in actual behavior. 12, petitioner introduced children to affair partner many times against father's expressed concern. 13, that court is about the children's best interest and parental rights, not just the petitioner's. 14, that due process has not yet taken place for any of the council's orders. She was ordering me around to not talk to my friends and not talk to this person and that person, and to only text once per day, even though there was mutual text after that. Since the above did happen in fact, I pray that this court grants the following relief. 15, hearing be scheduled to present more evidence supporting the continued malice, Ames' prejudice, and unethical behavior with her present. 16, all financial affidavits be filed by both parties with court to allow court's review. Petitioner must file original and corrected financial affidavit less tax returns with court. 17, all petitioner submissions be filed with the court. 18, Heidi Ames be called into court for questioning to clarify my right to talk to mutual friends and family, witnesses, and those in contact with my children, and that the court orders I may use that right without fear of prosecution. 19, Heidi Ames be sanctioned as court sees fit, and those proceeds go to aid Robert Tangway legally in this matter. So that was from November 22nd. It wasn't even that long. And that was prior to the fictitious domestic violence petition being filed. At some time, we're going to read all of these pleadings and record them forever in time. So here we have November 29th. This is what she wrote in response to a motion, which I didn't show you. I actually don't have it here. I got to find it. But that is a motion for to order mediation. I apologize. This is actually a lot. I'm learning a lot myself about myself. And it's good exercise. So I filed that motion on the 28th. On the 29th, she filed enclosed, please file for filing, please find petitioner's objection to respondent's motion for hearing slash deposition of petitioner's counsel and objection to motion to change temporary hearing in structuring conference. Now comes the petitioner, redacted, by and through her attorneys, Moore Ames Law, and hereby submits the pleading. The parties are parents of 2 children. The parties were never married. I'm just going to take out some of the small stuff. The parties were never married and the relationship ended in August of 2021, and Mr. Tangway moved out in November 2021. Since then, mother has been primary caregiver for the children, with Mr. Tangway having parenting time as agreed, usually separating the children and having each one night for dinner and sometimes together on Saturdays. He refuses to have overnights with both children, preferring to only take the oldest for an overnight once every few weeks. By the way, I was in a 1-bedroom apartment, which I moved from a drug-infested, what do you call the 1 rooms besides that? So I had a bedroom at least, and my son was sleeping in my bed with me, next to me, because that's the state that I was removed from the house for no reason besides that she just wanted to move on and date other people. I guess I'm not going to read everything because it's not relevant. What I do want to read that is relevant, and then I'm actually going to go because this was a great test, and I think we got some stuff that might be able to be used, if not used in the future. 7, after filing the parenting petition, undersigned counsel sent email correspondence to Mr. Tangway asking that he not enter Miss Andre's residence, the giant residence, and remain outside at parenting exchanges. Only text and call about the children and no more than once per day. Not come onto property when exchanging the children. Not threaten legal action. He threatened to file civil action for emotional damages and damages to his career because of the breakup. Not contact mother's family and friends or other parties about her, such as her then ex-boyfriend's ex-wife. To be realistic about the parenting schedule, in that his demand to see the children every morning and every night was not reasonable. Actually, lots of parents do that, and including the police officer living below his ex-wife, or at the time, at one point, his current wife. Despite these reasonable requests, Mr. Tangway's response was a lengthy defensive email in which he stated, in part, I did not cause any fear or anxiety. That exists within mother's mental issues, which she still has not addressed. It's concerning that mother has kept a loving father away from his children in pursuit of her own interests. It is disrespectful that I cannot enter the home of my children and paints me in a bad light in their eyes. I can contact whoever I want, especially if they have contact with my children. That is normal. Ask any parent. They have a right to know where their children are at all times, and they also have a right to decide who they are around. It's that simple. Just because one person no longer wants to be in a relationship does not mean that that just automatically ends and they get to confiscate the family. And so that's where we're going to end up getting to, is because family law is not yet settled. It's all hoopla, because women and children used to be property. And when you look at the Constitution, there are rights for property. And if you break up a business, you can't just say, I don't want to be in the business anymore. Here, I'm taking it all. No, or I'm taking half. You're not even entitled to half. If you just decide to break a business up, say you and a partner have a business, such as a car dealership, and you go, I don't really want to do car dealerships. I kind of want to like go see this other guy and do car dealerships with him. I'm going to leave. Give me half tomorrow. Okay? No, you can't do that. It's simple. In subsequent emails, Mr. Tangway accused mother and her family of alienating him because they did not invite him to her extended family events or send him a Christmas card. She didn't even send me a Christmas card. She already started an affair at that point, was talking to the guy every night. She didn't even have the kids make me a Christmas card, which was the point of it. And that's what I was complaining about. Meanwhile, I sat with our kids, and I guess they're her kids now, technically. Sat with the kids and made her card, Grammy and Grandpa card, and all that stuff while I was at the paternal home, while she was at work, or they were sick, and so on. Because we all got COVID when we left, because emotionally, our immune systems were down. 10. He left his employment. It is unclear why he blames petitioner and undersigned counsel and is not making any efforts to find new employment, instead claiming he is self-employed and has no income. Lie. They just write on it like lie. He refuses to contribute towards childcare. Not true. On September 30th, 2022, undersigned counsel attempted to calm the situation and sent Mr. Tangway an email that read in part, as I tell my clients, at the end of any relationship is like a death, and each party goes through the grieving process in different ways and at different times. You can have one party that has felt this coming for some time and therefore reaches acceptance more quickly than another party who did not sense it coming and or, even if they did, do not want to believe it was coming. You both are going to move through anger, denial, bargaining, depression, and acceptance at different times, and that is okay. Meanwhile, she knew for a fact that 2 weeks after I moved out of the house, she posted online and started an affair as a mistress with a married police officer. But she wrote that stuff, by the way, and charged a client. With respect, this is what she also wrote in the email. These are the excerpts. With respect, I apologize. All of that said, if one party is ready and wants their relationship to be over, it is over. Erica remains steadfast in her choice to end the romantic relationship, but work on a peaceful co-parenting relationship with you. By taking my children and hiding their location without any permission out of state for an extended period of time and refusing to bring them back, it's co-parenting. It is not my place to change her mind, talk her out of it, or tell her to make a different choice. Perhaps counseling would be helpful for you, so you are able to work through your emotions to find acceptance and separate them from this process, which is a legal process. It wasn't legal. With respect to the legal process, I am glad that you had a good experience at the courthouse. The clerks are all amazing and do their jobs well. They cannot give legal advice, but they are a wealth of knowledge regarding the process. In the meantime, it would be helpful if you could send me a proposal for a realistic interim parenting schedule while we are all waiting. Mr. Tangway responded by emailing, "Thank you. I've heard that exact explanation from Mother. It comes from an industry that profits off of selfishness targeted at the person ending the relationship. The willful ending of any relationship is a choice, where typically death is not. A relationship can be repaired, reborn, reset." She bolded. Death is permanent. That's what I wrote. Death is permanent. So it's not like that. This was a very calm exchange. And by the way, I want to bring up when I wrote, it comes from an industry that profits off of selfishness targeted at the person ending the relationship. That's in reference to the social media stream of spam that many women, unfortunately, typically get and causes them to break up the family. Which, if you do some research, Title 4D is specifically set to grant money to have the states, which is the child support, to have the states promote marriage, two family or two parent families, and also to prevent fraud and investigate fraud. That's what the money's for. They want us married. There's better outcomes with marriage. Marriage isn't always exciting, or a family is not always exciting. Trust me, there's times that you just want to sleep when, especially when kids are so young. These kids were, one of them was 2 at the time. The night before I left, he fell asleep on my chest, and that was taken away from me and from him. And just to move on, as they say, it's just ridiculous. This is just drivel. There is no legal standing for it. Death is permanent. Mr. Tangway went on to say that mother is not allowed to have another romantic interest around our children, whether awake or asleep, as it is clearly detrimental to the development and security of our children. The mandatory class for child trauma I would like to take in person with mother. We should have counseling together because the issues are affecting our ability to communicate as parents. This is an email I wrote. The issues are affecting our ability to communicate as parents, and our solo counseling has not helped because no relationship can be helped without 2 parties. Just because one party does not want a romantic relationship with the other parent of their children does not mean they can demand a schedule that works for only them or grants them extra free time. It does not entitle them to go out, date, vacation, or do whatever they want at the detriment of the children or before the matters are sorted. It is supposed to be difficult, sad, and lonely to stop the unavoidable trauma that inevitably ensues removing a parent from his or her children. While mother claims to want stability, she has ended that by forcing me out of their home and randomly and consistently leaving our kids with her grandparents, with her parents overnight, and introducing them to a married man she is no longer seeing. As for my time with the children, it should be every day in a manner that closely resembles a full-time parenting relationship, even that if that inconveniences the mother's social expectations. Very calm, no violence. Orderly, I believe so. Do you? 14, Mr. Tangway continues to be combative, irrationally, and frankly intimidating. 15, Mr. Tangway continues to harass the petitioner, sending more than 50 messages on November 19th. He continues to enter her home, going into the mudroom on numerous occasions at parenting exchanges. By the way, she had no evidence of such because it didn't happen. I followed that. I didn't do that when she told me not to. Going into the mudroom on numerous occasions and at parenting exchanges and refusing to leave when asked. Not true. He continues to open the door and enter her personal vehicle at exchanges for the children and laughs when she asks him to leave the vehicle on video. By the way, she texted me multiple times at my apartment during an exchange to come out and give my youngest 3-year-old son at the time candy at 7:30 at night because I wouldn't give it to him in the morning, which she gave to him because it's, as he said, and I remember this, that Miss Steffi said that there's no candy at school. This is a 3-year-old saying that. He knew he was not allowed to have candy and sugar before bed. So she set it up and then recorded me on video. He continues to send long, outlandish emails filled with vitriol and hate. He continues to call her and her parents names and swear in front of the children. 16, Mr. Tangway refuses to mail or email pleadings and demands to hand deliver them to undersigned's counsel's office, even approaching undersigned's counsel assistant in the parking lot, causing her to fear for her safety in broad daylight. I added broad daylight. And I was very, very calm. And I was actually wearing better clothes than I am now. Dress slacks and such. Undersigned counsel asked Mr. Tangway to stop and either mail or email the pleadings, but he stated, "You have a place that is open for business and are conducting business as a lawyer. As a lawyer, you have to receive paperwork for your clients. It is the job. If your assistant cannot handle receiving paperwork, perhaps she should be on disability or work remotely. If you cannot conduct business as a lawyer, please don't operate as one." Bold. Bolded. So here's the story. On the 28th, I hand delivered the motion. And that was the first time ever after the 5th time that I hand delivered motions, which it says 6 or 7 times in the court rules that hand delivery is an option. That was the first time she mentioned it. On November 29th, with, as we're going to get to, is her motion asking the court to file her domestic violence petition because I'm out of control. Mr. Tangway went as far to attack the personal appearance of undersigned counsel on November 7th, 2022, stating, "Perhaps you should attend counseling for your depression or exercise. Excessive weight is often caused by those issues. It might make you a better, happier person. You might become a more effective lawyer that solves issues." Bolded. But she failed to leave out that I also added right there after that, immediately after. See how that feels? Now, if we can stop fighting and get to the issues, because she was harassing me in writing. And I brought that up in response to this. But anyways, you can see what lawyers do is they just lie and omit things. Nope. No, we can't. PJ, we cannot. Not my children. Look up Miller v. Todd. Sir, I'm not a lawyer, by the way. Look up Miller v. Todd and find out that eventually, after his children were, their vaginas, quite frankly, were touched by doctors over and over again. After 8 years, he finally found that the mother was incapable of being a mother and a co-parent. That's Miller v. Todd. So, anyways, and to continue his harassment, Mr. Tangway has now filed 2 frivolous motions that are nonsensical and request relief that is simply unheard of, and he will likely continue to do this until he is told to stop by a judge. I wrote in my little notes, that's why I want a hearing. That's what the motions were. I want a hearing, please. 19, in his motion for hearing, deposition of petitioner's counsel, he again attacks the petitioner and her legal counsel, seemingly taking great offense to the suggestion that he consult with a legal counsel to better understand the laws about parenting time in New Hampshire, as well as seek counseling to help him process the end of a relationship and help him accept that it is over. 20, Mr. Tangway does not seem to comprehend how outlandish and unorthodox his behavior is, and that it is a form of abuse. 21, he requests that undersigned's counsel be called into court for questioning to clarify my right to talk to mutual friends and family. Again, this request stems from him contacting and harassing the mothers friends, and family to convince them to tell her to get back together with him, as well as contacting mother's then boyfriend's ex-wife, which, by the way, I have evidence that we talked for 45 minutes willingly, and none of her friends. They're still friends with me on Facebook. So hogwash. He asks for counsel to be deposed in his motion title, but does not mention a deposition in the written attachment. Well, that is because, according to the RSAs, judges are allowed to give depositions. So I asked for a hearing, and the judge could legally grant a deposition. And I knew this without reading the law. This is at the beginning of the journey. People know the laws. PJ, by the way, I can't because, as you'll find out, and if you follow our work, that what happens is that they constantly harass you and bring you into court over and over again. If I was to let this fraud continue, I would be in jail at this point, and you'll find out. I hear you, PJ, but you gotta hear everything, and I appreciate you. Look at my other content, you'll find that there's fraud without, read New Hampshire Oliver Twist. I know what I'm doing, and this is the only thing I can do, and I desperately want to see my children, so much so. But I can't under false pretenses. You just can't. I have a piece of paper that shows that a guy's been arrested 3 times for following court orders with a fictitious domestic violence petition, and so on. Okay. In a second motion, his motion to change temporary hearing instruction conference, Mr. Tangway requests that the court do not find the 30-minute temporary hearing instruction conference scheduled December 22nd at 2 p.m. sufficient for my parental rights, and asks that it be a 1-hour hearing for a motion to order mediation, dismiss or extend temporary hearing. At the start of the case, petitioner wanted to try mediation and offered the same to Mr. Tangway. However, he made it clear in multiple emails they would not agree to any parenting schedule that did not allow him to see the children every morning and every evening of the day. I wrote, just in my notes, mediation is to get a better understanding of why. And it says that. In fact, Judge King wrote that in the letter that he sends out to everybody. Should also be noted that Mr. Tangway failed to appear for the first appearance, and he only appeared at the second date offered by the court. How does that work? And by the way, they held that against the court rules, which say that all first appearances must be before a judge, not a case manager. So look that up. Finally, he states in his own pleading that the parties do not agree on parenting or finances, leaving nothing to mediate. We haven't been able to discuss because you've isolated ourselves for lucre, for money. Simply put, Mr. Tangway is utilizing the legal process to further harass and attack the petitioner, which constitutes abuse. The petitioner has tried to refrain from filing a domestic violence petition, but at this point has no choice, as Mr. Tangway has demonstrated he will not listen to her or undersigned counsel with respect to her boundaries, which is a fact, not an opinion. Which is not fact, but an opinion, I meant. 29, these motions are frivolous and a waste of the court's time and resources, as well as the petitioner's limited financial resources. At this time, petitioner requests that the court proceed with a temporary hearing on December 22nd, 2022, so that there can be court orders in this case which are desperately needed. Mother also requests she be awarded her attorney's fees and costs for the necessity of having to respond to these frivolous motions. There's no necessity. Actually, it says in the court rules you don't have to respond to any motion, especially with lies. 32, it should be noted that the undersigned counsel has intentionally kept all communications with Mr. Tangway in writing so there is a clear record of what was stated to and by him. These emails will be produced as exhibits at the temporary hearing so the court can review, understand, and see what the petitioner is dealing with. Apparently, I was dealing with someone who doesn't follow the professional codes of conduct, which state that in roughness, that lawyers are supposed to treat those without lawyers with courtesy and opposing counsel with courtesy. That's not courtesy. Specifically not talking to me. Finally, the petitioner requests that the court order Robert Tanguay to stop filing frivolous pleadings with the court and or issue an order recognizing that the petitioner has a standard objection on file to any pleading filed by him. Mr. Tanguay needs to be stopped. The same needs to be stopped. A, the respondent's motion is therefore denied. B, temporary handing remain on the docket. And this is what got me sick. I was with my son on December 1st, took a picture, feeding him steak dinner, my 3-year-old son, all cut up. And I went and checked on the mail, and I opened the mail and found this, and this made my stomach sick, and I had to drop him off to his mother's house because I was sick to my stomach that she actually did this. C, that mother's domestic violence petition be granted. D, that mother be awarded her attorney's fees and costs for the necessity of having to respond to these frivolous motions after submission of an affidavit of fees. E, and such other relief that is necessary. She filed this one day before filing a fictitious domestic violence petition, which the lawyer wrote up in the third person and is fraud to gain strategic advantage in the court case, instead of having mediation, which would have solved everything. They're not going to put me in jail, PJ. They can't put me in jail. They can't, because I have broken no laws, even though they ordered me to violate the frivolous and false protection order, which is in violation of 173B, section 8(3), I believe. I have it. We'll be reading more of these motions in the future. For right now, I'm gonna go eat some food. I think this was a success. Not many people have watched. It'll be interesting to see and document the fact that I can talk straight for 57.5 minutes with ease. My voice just getting a little soft. I do appreciate all of you. I hope that this helps. We're going to do something more formatted and such. And I think that this is a big step, and realize that this is not really promoted, has not really been promoted, and it's put on a Sunday. God bless. I'll respond to comments later. And welcome PJ to the community. And I hope that you can find some stuff. But I know for a fact that what I'm doing is right, and I know what the law is without knowing what the law is, and I know what my rights are, and I'm going to demonstrate that. But I do desperately want to see my children, and I know when they're going to soccer, and I can, but under these pretenses. And if you've ever had an injustice, you know that you can't move on with it. They have caused damage to my children, to me, and to the mother, quite frankly, because the mother doesn't realize, she knows what she did is wrong, but she's in a finger trap. Now, if she admits that her lawyer lied or she lied, she can be in trouble. And she's already seeing someone new, which is, and by the way, she posted all this stuff to my whole community. I can't just walk. I want to see my children. But the end result, if you look at Miller v. Todd, is that she is an unfit parent and abusing the children. And I'm not a lawyer, but I need to see them. And so yeah, check out Easy Legal Sue. You'll see some resources there, not legal advice. And then look at the videos on the channel. Make sure you subscribe if you see this, and see you around.